In this clip, I want to hone in on one civil right, namely the freedom from being subjected to torture and inhumane and degrading treatment. The reason for me focusing specifically on this right as opposed to another one, such as freedom of assembly, the freedom of expression, or another civil liberty, is mostly that I wanted to give you the opportunity to answer the reading questions, and all of the three are related to this right, so I'll address them in this video. I want to give you the opportunity to address them through listening to the podcast with the former UN Special Rapporteur on this subject, Manfred Nowak. And if you actually have only read the chapter and not listened to the podcast, I would strongly recommend you do listen to it, because it's really a fantastic first-hand account of what it means really in practice to be the person in the UN level, in the UN system, in charge, checking whether states are in compliance with the human rights obligations that they have. That being said, there are a few specific features that characterize and make this right very interesting and relevant. But before we get to that, let's firstly look at the definition of the right as laid down in Article 7 of the ICCPR, which states that no one shall be subjected to torture or to cruel, inhumane, or degrading treatment or punishment. In particular, no one shall be subjected without his free consent to medical or scientific experimentation. It's interesting to note the historical kind of feature in this provision, which is really the second part about medical and scientific experimentation. And obviously, it's again the experience of persons during the Nazi regime, and particularly Jewish persons who were subjected to medical experiments, scientific experiments, by the infamous criminal doctor Joseph Mengele, that brought this part into the provision. This, for example, is missing in Article 3 of the ECHR, which establishes the same right. And indeed, we can find the prohibition of torture, inhumane, degrading treatment and other instruments, including Article 5 of the UDHR, the Universal Declaration on Human Rights, as well as Articles 5 of the American Convention on Human Rights, as well as the African Convention on Humans and People's Rights. And not to forget, of course, there is the UN Convention Against Torture, which spells out explicitly many things that we might consider or argue are implied in these various instruments that I just mentioned, such as, for example, indeed, the duty of the state to investigate when there are allegations of torture by other actors, but also maybe more positive obligations, such as the obligation to provide compensation when a person has been subjected to such treatment, to educate officers, law enforcement personnel, and so on and so forth, who might be running a risk of engaging in such conduct, as well as the requirement to systematically monitor, review, for example, the prison system, detention systems more generally, which is another way to make sure that this right is protected in practice. And of course, it establishes the UN Committee Against Torture, which monitors the compliance of state parties in this regard, and which also possibly receives individual communications. Now, to get back to the substantive right, and indeed to the first question that I posed, the prohibition of inhumane and degrading treatment and torture is also seen as a jus cogens norm. What does this mean? That means a few things. In general, we can translate it as a peremptory norm. And that means firstly that there cannot be any treaty modifying the obligations that exist. That is so because as a jus cogens norm, it is also automatically customary international law. So even if you have not ratified the ICCPR or you have not ratified the Convention Against Torture, you are still in fact bound by the prohibition of torture and inhumane degrading treatment. Now that doesn't mean that every state, because they believe they're anyway bound, have also therefore ratified the Convention Against Torture. In fact, it is quite a lot in fact, but it only has 171 ratifications. So there are few states, most notably, for example, also India, that have signed but not ratified it. The issue here is not that they can subject their persons under their jurisdiction to such treatment, indeed that is prohibited, but that not every single item, such as the education system or the monitoring, or indeed subjecting yourself to the jurisdiction of the Committee Against Torture, is being accepted by these states. Nonetheless, and just to repeat, every state has, because it is a peremptory jus cogens norm, has the obligation not to engage in torture and inhumane and degrading treatment. And indeed, there is no derogation and no limitation allowed here at all. Boven would add that this elevates it to the status of a core right. But again, as I explained in the previous clip, you need to be careful to make this hierarchy of norms. Now, it is clear that by nature of being a jus cogens norm, there is something specific, something extraordinary to the prohibition of torture and inhumane and degrading treatment. And this brings us in a way already to the third question that I posed to you. So how does this right compare to the right to life? And obviously there are the commonalities that are firstly obvious. So we in both cases talk about rights that are related to the physical integrity of a person. They are also primarily, no, not completely, rights that entail negative obligations for states to not engage in such a conduct. And there's also a duty to investigate if indeed other actors, private actors, are engaging in such a conduct. That being said, the prohibition of torture and inhumane and degrading treatment is a jus cogens norm as a whole. Whereas in fact, when it comes to the right to life, it's only the core part that can qualify as such. And there are in fact certain circumstances, such as for instance self-defense, but also warfare, and indeed potentially capital punishment as a sort of criminal sanction, that are accepted as exceptions to the rule that the right to life must be protected. That said, the exceptions or limitations obviously here are quite narrow. The final difference then is in the UN framework. And as I already said, there's a convention against torture. Now there is no corresponding convention that goes specifically to the right to life. There's also a special rapporteur on torture, but not one on the right to life, although there is actually one on extrajudicial summary or arbitrary executions, which brings us to the question of what these special rapporteurs do. Now, already, as I said, if you haven't done so, listen to the podcast that I've assigned for today. It gives you an extensive and fascinating answer to this question. But just to very briefly address it here, special rapporteurs conduct country visits to gather information and see whether states are in compliance with the norms. And in the case on the special rapporteur on torture, more specifically, they go visit, for example, prisons or closed institutions in order to see if everything is in order there. Based on the information that they have gathered, they then publish reports that are publicly available and that are then also used by national organizations in the country in question, but also the international community, other human rights bodies, in order to pressure, shame the government into compliance if there is a problem with compliance. Now, you may question the efficacy of this kind of procedure, but I think it's quite telling that states sometimes deliberately try to avoid the visit of a special rapporteur because they are indeed worried about the repercussions of a negative report. That concludes the videos for this week. I look forward to discussing all the issues with you on Tuesday.